Good morning. This is Rajeshkumar. Today we are going to analyze one problem question related to the offer, acceptance, withdrawal, and the timing of communication. Disclaimer: the video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. On 4th March, boom, the post information on their website stating that shares in their video conferencing company can be bought at £3 each. That afternoon, Raj sees the information on the website. He fills out the online application, prints a hard copy, and posts the application to Boom. After posting the letter, Raj regrets his decision and goes home to email Boom, informing them of his change of mind. Boom received the application on 6th March. The secretary of the company immediately emails Raj, informing him that he will be allocated the full number of shares applied for. Later that day, the secretary sees Raj's email but does not reply as she must leave the office as the country enters into a lockdown owing to a viral pandemic. As a result of the pandemic, Boom shares price suddenly rises. On 8th March, the secretary of the company contacts Raj by email informing him that the shares are no longer available for purchase. Raj, however, has changed his mind again and wishes to purchase them. We have to advise Boom. Let's analyze this problem question. To determine if a binding agreement was formed between Boom and Raj regarding the shares, we need to evaluate the offer, acceptance, withdrawal, and the timing of communication between Boom and Raj in chronological order. Analyzing each communication will help clarify Boom's potential obligation to Raj and whether they are legally bound to sell him the shares. Step 1: a Boom website posting on 4th March. Is it invitation to treat or offer? Whether Boom's posting of share information at £3 per share constituting a binding offer or an invitation to treat. Boom's online posting likely serve as an invitation to treat rather than a firm offer. Under Patterson versus Crittenden, advertisement even with specific pricing are usually considered invitation to treat and not the binding offers. This distinction allows Boom to reserve the right to accept or reject the applications. Hence, the Boom's website posting is most likely an invitation to trade, which means they are not obliged to sell the shares to anyone who simply submits an application. What about the Raj online application and the postal submission on 4th March? Whether Raj act of posting the application creates a binding contract. By filling out and sending his application via post, Raj made an offer to buy shares at £3 each. According to the postal rule Adams versus Lindsay, an offer or acceptance communicated via post is effective when the letter is sent, unless otherwise specified. However, the postal rule does not typically apply to offers, only acceptances. So let's conclude. Raj mailed application represents his offer to buy shares, but no contract is formed until Boom formally accept this offer. What is the impact of Raj email revocation on 4th March? Whether his offer by emailing Boom before they accepted it? Under Bryan versus Van Hoven, an offerer can withdraw an offer if the withdrawal reaches the offeree before they accept it. Raj sent his revocation via email, a method which is generally instantaneous, meaning it could be effective upon receipt, depending on when it was seen and processed. In the Bremen's case, the court held that a revocation sent during business hours was deemed received when it could reasonably be read. Here, although the secretary did not immediately see the revocation email, it was sent before a Boom's acceptance was issued, making it a valid revocation if it reached Boom's inbox before they processed the acceptance. So let's conclude. Raj emailed the withdrawal of his offer is likely effective since it was sent before Boom accepted the offer. Hence, the next stage is the Boom's email acceptance on 6th March. Whether the Boom's acceptance email creates a binding contract. Boom's email indicates acceptance of Raj's offer, suggesting an intention to form a contract. In Entos Limited versus Miles for East Corporation, the court clarified that electronic acceptance are effective when received, not when sent. Boom's acceptance here would normally create a binding contract, except that Raj had already revoked his offer by email before this acceptance. So let's conclude there's Raj's revocation likely reached a Boom before the acceptance was sent, and no binding contract was formed. A Boom's acceptance, therefore, is ineffective because the offer was no longer open. What about the Boom's subsequent withdrawal on 8th March and the Raj's reinstatement of interest? Whether the Raj can enforce a sale after the Boom's withdrawal on 8th March? The Raj initial offer and withdrawal were both completed, and Boom had already responded to Raj revocation by indicating the shares were no longer available. In Routledge versus Grant, it was established that a seller could withdraw an offer at any time before it is accepted. So the Boom's notification to Raj on 8th March that shares were unavailable effectively terminates any contractual obligation. If Raj now wishes to buy the shares again, he would need to submit a new offer to Boom. So Boom would not be legally obliged to sell at the original price, especially as the market conditions have changed and the share price has risen significantly. So the Raj cannot enforce the sale under the initial terms since his original offer was revoked and the Boom subsequently withdraw their availability of shares. Any sale would require a new offer and acceptance under the current conditions. So let's conclude. Boom's initial posting, this is likely an invitation to trade rather than a binding offer, allowing Boom discretions over acceptance. What about Raj's revocation? The Raj email revoking his offer was sent before the Boom's acceptance, making the revocation effective and preventing the contract formation. Boom's 6th March acceptance. Although Boom accepted a Raj offer on 6th March, the acceptance is ineffective due to Raj's prior revocation. Raj renewed the interest on 8th March. As Raj initially withdrew his offer, Boom is under no obligation to reinstate the initial offer terms. Boom may now set a new terms if they wish to engage in a fresh negotiation. So the final advice is Boom is not legally obliged to sell the shares to Raj at the originally stated price and may proceed with the shares according to current market conditions. Thank you.